Right, welcome back. Voting coverage continues here on the SABC. The agenda, perhaps in this next story, we've seen an alleged family dispute regarding the custody of children having turned violent at the Matsediso Primary School in Katlehong on Monday. Now, according to reports, armed men forcibly removed 2 children from the school. Videos of the incident circulated on social media showing 3 men wielding 2 pangas and an AK-47 rifle whilst taking the learners from the primary school. Now, in South Africa, courts usually grant guardianship to both parents as part of a divorce settlement. However, specific circumstances may lead the court to award sole custody to one parent or even to someone who's not the child's biological parent. So for more on this, I'm joined in studio by Isaac Moselana, attorney at Nkosana Inc., specializing in family and commercial law, perhaps to unpack how custody works in particular. Isaac, good morning and thanks for your time at this hour.
Good morning and thank you for having me on the show.
So many questions. I'm not sure where to start. Perhaps at the beginning, we could look at what makes a parent, mother or father, unfit for custody. When does a mother lose custody rights? When does a father become unfit? Help us unpack that. I guess context is also important.
Yeah, and I think maybe we start at the beginning. You know, in South Africa, we recognize more a person or a parent who has parental responsibilities and rights. And the Children's Act does provide that in terms of Section 18, Section 19, Section 20, and Section 21. And it characterizes different types of parents. So we're talking about parents who are, at the time, they are married. And they will have parental rights and responsibilities, both of them. And then we'll talk about unmarried parents. You know, for instance, a father who seeks to have a relationship with a child who at the time would not have automatic parental responsibilities and rights and has to undergo certain procedures for them to eventually be recognized as a parent with such. Because, you know, I don't know if it's a default setting or what, but usually at the hospital when the child is born, the mother will be given opportunity to fill in the details of the child in order to register the child. And when they then do that, sometimes they don't obviously put in the details of the father. Then when the father wants access, doesn't have automatic access, then the father would have to go through processes where they would have to go to what we call the offices of the family advocate. It's a free services or social services provided by the Department of Justice, where you can go and say, I'm denied access, or I need to have access, or I need to be recognized as a father who needs to have parental responsibilities and rights. Now, all of this, then it allows the family advocate offices. Inside that office, you've got social workers, you've got family counselors, you've got obviously attorneys, and they do a lot of evaluation on both the parents and also the minor child, and they determine whether the minor child has capacity mentally so to be able to illustrate or tell the officers where the child wants, what the child wants, where does the child want to live, and they take that into cognizance and consideration and eventually then determine what is the best interest of the minor child. Now you lose those benefits if upon assessment you've done something very bad, because the standard is very incredibly low for you to lose your parental rights and responsibilities as a parent. For instance, there could be a protection order that you've harmed a child. If you've harmed a child, then you may lose the parental rights and responsibilities. Not necessarily the whole entire issue of custody, because I don't think in South Africa the general idea is custody as you see it in America. It's the issue of parental rights and responsibilities, or responsibilities and rights, is whether or not this person has the capacity to take care of the child. Can we leave this child with this person? So you don't necessarily take away someone else's parental rights and responsibilities willingly. They have to have done something that affected the child, where it will not be in the best interest of the child for you as a person, whether you're a parent or whether you're a grandparent, to have access to the child.
Okay, thank you for also touching on preferences and considerations by children and whether children also have a voice, because I actually then want to look at, in the event of a death of a parent as well, the dynamics that affect that process.
So the standard procedure is that the child, it will be in the best interest of the minor child to have a relationship with both the maternal and the paternal. Once we've established that, though, if the parent passes away, it does not exclude the grandparents or the next of kin of the mother or the father or the person who has passed away to then apply to the court to say we also still want to keep a relationship with this child, and then there will be arrangements. The Children's Act allows for the survival, the current living parent to then enter into a contract with maybe the grandparents or the aunt or the uncles of the other side of the family to say, I will give you certain parental responsibilities and rights in order for you to have access to this minor child, and we'll have an agreement as to when the child can come to you to visit. You guys can have contact and access as if the parent was still alive.
Okay.
Now, if that agreement doesn't take place, you can still approach the court and request the court to assign you the very same parental responsibilities and rights. You will still undergo through the same phenomena or same procedure of a social worker, of a child psychologist, and the family advocate's office. And the family advocate office will then do a report provided to the court what would be in the best interest of the minor child. If the main key issue is what is in the best interest of the minor child.
Okay, so speaking about the best interests of the minor child and the custody options available for divorced or deceased parent or parents, this instance that's come to the fore with the alleged pastor, how better could the situation have been handled from your vantage point, given the facts at hand?
So obviously from a standing point is that we don't necessarily have the full facts on the table.
Sure.
You know, because we don't even know whether or not the alleged pastor has parental responsibilities or rights. We don't even know the relationship between him and those children. There's a lot of rumors around whether or not he's the grandparent or whether he's the father. We don't know anything. But what is important in that situation is that for us we need to investigate as to what led him to eventually do what he did.
Yes.
And then we need to understand whether or not proper procedures have been followed. But for me, I would say the first thing is to send both the alleged pastor, everybody involved who's a parent in all families, to the offices of the family advocate, for them to then call everybody involved and then interview the necessary parties, the children themselves, to find out what's taking place. And they can put a report, which that report will be taken to a social worker. The social worker can then bring an application before the magistrate to determine what is the best interest of the minor child. That also does not stop all of these people from then pressing charges if the alleged person who did that did not have any rights whatsoever, or could not even potentially could have any rights. You know, it could be kidnapping or taking a child, removing a child from a place where they're not supposed to be removed unlawfully is also a criminal offense that a person can be arrested for. So it's important for us to get the context. It's important for us to understand at the end of the day what led to a person to decide, I want to go and take the children. Perhaps maybe they're being denied access and so on. It does not justify it, but it does not say that we should at the same time cast everybody else, in a fire hell. But we need to investigate, because at the end of the day, what is core is the best interest of the minor child. That is where should be our starting point. If it is not in the best interest of the minor, obviously we would say, because the child was in school, the children were in school, that would not be in the best interest of the minor child to go there wielding all sorts of weapons and remove the children there. And obviously removal of children, especially from a school setting, would not be in the best interest of that minor child. But in this instance, after a while the milk has spilled, it's important to bring all the necessary social services facilities for the government, because our government, the constitution or the government we eventually have post-apartheid managed to create institutions that protect minor children. And we're supposed to use all of them in order to assist these children who are at the heart of this phenomenon. How
lengthy is that process? I mean, obviously context and everything is relative, but just are you able to give timelines? And if we're going to look at the law at large, family law, some gaps that still pervade the system, anything you'd like to note at this point or challenge? So if you bring a high court application or even a magistrate's application, you can create timelines for the offices of the family advocate as to when should they make an assessment, when they should draft the report, and when they should present the report to the actual court that you made the application to. It doesn't take long. But recently I've also had clients where we've instructed them to first visit the offices as well, and the length is about 2 to 3 months for them to be called, and then once they are called, it will take another a month or two or so for a report to come out. You see, so under normal because at the end of the day, a lot of people are recently discovering these offices, and they are also going to these offices, and these offices are overwhelmed with a lot of work, particularly because it's not just
individual parents who want access. It's also the situation where child-headed homes, then social workers will be invited to go investigate, and they'll have to do the work as well. And then you have situations where people have private attorneys who then make application. You would all sorts of people requesting the services of this office, and then they ended up becoming overwhelmed with work. But I'm currently happy. I am well assured of both Gauteng and as well as Limpopo, because those are institutions where I've literally engaged with and worked with. I know for a fact that they're quite timeless in expediting these matters.
Okay, and in terms of expenses, given the resources available, talk to us about the reality on the ground on that front as we conclude.
So if you decide to approach the offices of the family advocate, it's a free service. It's like going to the maintenance office if you know you're a mother and you're seeking maintenance. If you decide to go to the legal route, you'll have to pay attorney's fees or a law firm's fees, but eventually they will use the very same services which are free. So people should be welcome to go to the offices of the family advocate to just inquire, I need help, this is my problem, and they will help for free. They should start there. Every time I always say to them, instead of running to the children's court to speak to the clerk, go to the offices of the family advocate and inquire, how can I start the process for me to eventually have these parental responsibilities and rights.
All right, Isaac, thank you for joining us at this hour and for breaking that down. I'm going to leave the conversation there for now. Isaac Moselana weighing in. We're shining a spotlight on custody battles in South Africa, the do's and don'ts, and just in determining the best interests of the child or children at large. Thanks to Isaac for joining us at this hour. Let's leave that conversation there. We continue with more news and updates. We're obviously seeing that some sporting action now. South Africans continue to fly the flag high for South Africa. We're looking at all the medals that have come to the fore. South Africa's hopes of a medal in the men's 4x100 meters relay obviously also set to keep our hopes alive.